Hello, everyone. Welcome. Thank you for joining us for our Digital Health Commercialization Seminar Series, which is co-sponsored by the Brown Lifespan Center for Digital Health and Brown Technology Innovations. My name is Allison Seeley. I am the Education Coordinator for the Brown Lifespan Center for Digital Health, where one of our strategic priorities is helping to develop the future of the digital health workforce through programming and events like the one that you're all joining today. I'm going to be one of your moderators for this session, and I'll invite our other moderator to introduce herself in just a bit. But in this seminar series, we are exploring the process of bringing digital health innovations to market. We've invited speakers over the course of the next month with expertise on intellectual property, regulatory pathways, market access, designing and evaluating digital health tools, and then pitching a product. So whether you are someone who is ready to pursue commercialization or you are just considering the pathways for scaling your innovations, we do hope that you'll take away some valuable insights throughout this series. To stay up to date on all of the sessions coming up this month, I invite you to join our listserv, which I'll chat that to everyone now. If you register for our listserv, you'll not only hear about future sessions, future seminars in this series, but you'll also be connected with our contact list to learn a little bit more about the exciting news and things happening at CDH. So fill out the link if that interests you. For today's seminar, we are going to be learning about intellectual property. I will not spoil all the details for you. Instead, I will let my co-moderator introduce you to our guest speakers today.
Good afternoon, everyone. My name is Melissa Simon. I'm a Director of Business Development with Brown Tech Innovations, which is Brown's Technology Transfer Office. So for today's session, we're thrilled to welcome Dan Holmander and Alex Barakis from Adler, Pollock & Sheehan. We'll be discussing IP related to digital health. So Dan is a registered patent attorney specializing in areas such as medical technology, software, and biotechnology. He advises on all aspects of intellectual property protection, and his team manages actually the majority of Brown's IP. He's also an adjunct professor with Brown. Alex is an IP and corporate attorney with more than 19 years of experience in law firm and in-house settings. He specializes in computer and communication networks, computer software, AI, ML, and biomedical devices. And prior to joining the legal field, he was an electrical and software engineer. So our presentation today will be about 45 minutes, and then we'll leave the remainder for questions. So welcome, Dan and Alex, and I'll let you guys take it from here.
Thanks, Melissa. Hope everyone can hear me okay. But so before we get started, I of course want to introduce, thank you for allowing us to come here today, Adler, Pollock & Sheehan, along with Alex Barakis. And we have a slide deck for y'all, which is going to teach a little bit about, and again, the audience here is kind of a wide variety. So we're going to talk, forgive those who are experts in patents. We're going to talk a little bit about some building block technology in patents. We're going to talk a little bit about AI, and we're going to talk a little bit about strategies. And to start off, before we get started, if there are any questions that you have, the idea here is that we're trying to get through these slides, and then at the end there'll be questions in the chat box, and then I know that Melissa and Allison will moderate those questions afterwards. So forgive me if I'm not ignoring you. If you're putting a question in the box, I'm going to handle those at the end. And if we can't get to them, we'll get to them afterwards. So without further ado, the purpose of this seminar is to talk about 7 main areas. Explain different forms of IP protection AI. Most people think of patents. It's broader than that. Thinking about patents in particular, though, because it's really where the crux of a lot of the issues are rising in AI. Examples of patents in the AI space, and also we'll talk also about digital health patents. What makes AI inventions patentable and what makes them not patentable through the eyes of the patent office. And then some strategies for getting patents in that space. And then we're going to talk a little bit broadly about trade secrets, trademarks, and copyrights, which are the 3 doctrines of IP protection, and try to teach you a little bit about how to develop your own intellectual property strategy around your invention. So AI, and I'm sure there are a number of people on this call that have their own view of what AI is, but I can tell you that there's one consistent message that no one can really agree what AI is. Okay. So it's been around since the 60s. There were pretty much no patent filings up until the early 90s on AI, and now all of a sudden we have an explosion of filings. And so each body has tried their own definition. We have NIST, National Institute of Standards and Technology, saying it comprises software and hardware that can learn to solve complex problems, make predictions, that require human-like sensing, perception, cognition, planning, learning, basically trying to simulate your own mental capacity. We have another recent bill from Congress here saying artificial intelligence to them is any system that performs tasks under varying and unpredictable circumstances without significant human oversight or that learn from experience and improve performance when exposed to data sets. As you can see, there's not a consistent message as to what AI is, and there is a even less so consistent message at the patent office. So let's talk a little bit about why these rights are important to the patent, why these rights are important, and how they can actually help you in developing an intellectual property strategy. The destination I want to emphasize is not a patent necessarily, because there may be things that may not lend itself to patenting. So the general rule is that 45 to 80% of companies' value lies today in its intangible assets, namely intellectual property. So that means if you're doing a spin out or startup, or you're building, a new technology, you're focused on IP. IP is incredibly important to capturing the value and translating that out of the university. But in general, you can't protect ideas, right? So, and then people will say, what's an idea versus what's actually inventive? Well, that's why they came up with these 4 little buckets here, okay? Trademarks, patents, copyrights, trade secrets. And at the university level, we're typically focused on patents. Why? Because it's publish or perish, right? Trade secrets are all about not disclosing things and keeping them secret. Patents are file your patent before you disclose it, and then you can share it with the world. So copyrights and trademarks also are important doctrines as well. And we'll talk a little about those. But the question really is, what do you do with these 4 tools? Okay, it's not simple. A common question we usually get asked is, hey, I need one of those patents. I need one of those rights that you're talking about, without a real clear understanding of why do you need those rights and what value is it going to be from your commercialization standpoint. And that's some of the things that we're going to talk about. But before you get there, you have to know the difference between these 4 rights. And again, some of this is basic to some of you, and some of it you're like, okay, it's a little bit eye-opening. But a copyright this is a kind of a formal definition. It protects original works of authorship, _authorship, because it's always a question mark with AI inventions, fixed and intangible medium of expression. So we all know literary works, musical works, dramatic works, sort of the basic, but software is a big part, and AI is a big part of what copyright is applied to. Trademarks, indicia affixed to goods or services as they travel through commerce. They indicate the underlying owner of those goods or services. Think Nike, Apple, all these popular brands. That's a name. IBM Watson is a brand of an AI technology. Patents, it's a negative right. Basically, it's an exclusionary right to stop somebody else from making, selling, using, distributing, or importing your invention here in the United States. And of course, there are rights like that in each respective country around the world, but not a right to use your invention. And a lot of people think that, hey, I need a patent because I want to do something. It's not that you need a patent to do anything. It's that you need to at least be aware of other people's patents and not infringe on theirs. And if you can get a patent of your own, incredibly valuable, especially when you're trying to commercial technologies and you license them. And then trade secrets, think confidential information. It's behind the wall. Nobody can see it. But if it were disclosed outside the wall of the company or university, it would have economic value. And we call it, when someone takes that, misappropriation of trade secrets. And again, in a company, trade secrets become a lot more important than a university says. I talked about earlier, we inhibit disclosure because of a competing because we need to do research. So what is a patent in particular? How do you get one? There's these tests, okay? And we're going to talk a lot about these tests because these are the hurdles to getting a patent. And the first one is it novel and non-obvious? That's actually, those are legal terms under section 35 USC 102 and 103. And novelty is really basic. Is there another piece of prior art? What's prior art? Prior art is anything oral written anywhere in the world. So is there a piece of prior art, single piece of prior art that teaches your invention? If there is, your invention is not novel. And if there isn't, your invention is novel. So not that high of a hurdle. With obviousness, and that's typically where we have a lot of issues around AI and software inventions, is obviousness, is where, hey, there isn't one reference, but there are a myriad of references that you stitch work together that teach the invention, that were basically around before you filed your patent. And that is a very subjective standard. I've actually spoken to people at the patent office and I've asked them to define what obviousness is, and I get an inconsistent message. And by the way, the allowance rate by examiner in individual art units varies anywhere between 5% and 95% in the same technology area. So, and that is because of what the word obviousness is. And again, we're going to get into some other standards where that same sort of subjectivity is involved. What do you get? 20 years to basically exclude others from using your invention. What kind of patents are there? Utility patents, design patents, plant patents. We're going to focus really on utility patents, but design patent is on the ornamental look of an object, or could be a website. For instance, Google has a design patent, the ornamental look of the website. Plant patent, think Monsanto, think of genetically more modified seeds. But utility patents, where it's at with AI inventions, software, we're talking provisional, non-provisional applications. Provisionals are the ones that are temporary, and they allow you 12 months to basically explore your invention further before you file a non-provisional application, which is the application actually will be read by an examiner and eventually will lead to a grant. A lot more I could teach you about that, but this really here to kind of get into the crux of AI. What's patentable subject matter? Okay, we're going to talk a lot about this today because this is another hurdle. So we talked about whether it's novel and non-obvious. Well, is it actually patentable subject matter? Meaning, can you even walk through the front door of the patent office to start? And these are areas that are clearly carved out by statute, said, hey, if it's an apparatus, a thing, it's composition of matter, think like chemical, method of manufacture, method of process using a particular device. Even business method patents and software AI are considered patentable subject matter. But there's a big caveat to that. What's not patentable? A lot of things that you would think go into AI and software. Think mathematical formula, algorithms, and to some degree, mental processes. All that is somewhere embedded in those AI inventions, but in how you actually explain that to the patent office in a technical, legalese way will make the determination whether they look at that as just purely an abstract idea or a mental process that can be performed outside of, say, a software environment, or something that's actually worthy of a patent. And that line we'll see is not clear and bright. It moves from left to right, depending on the year, depending on the court case decisions, and we'll give you some guidance around that. Talked about provisionals. I'm not going to spend too much time on it, but most important, and Melissa would kill me if I didn't say this, but please consult with your technology transfer office. If you're ever thinking about publishing, please think patent first before publish, just for a second, okay? And that's where provisional would come into play. And non-provisionals, again, more formal, much more expensive, and design patents, think Coke bottle, ornamental look. So let's get into what is AI according to the US Patent and Trademark Office, okay? And again, a third definition, right? These are the buckets that they've identified. And this pictorial came right from the patent office, okay? All these different buckets are what they consider to be artificial intelligence. And they give us a little bit of guidance as to what those buckets are. And the reason why we want to know about buckets is because we're working with the government, okay? When we're telling your story, yes, we want it to sound like it's a unique, novel, and non-obvious invention, but we also want to channel it through these buckets that are familiar to the patent examiners so that they can say, oh, I see the bucket of rules that applies. You're in knowledge processing, you're in speech, evolutionary computation, machine learning, planning, and control. I've seen cases like that before. I feel comfortable saying that it's eligible to be a patent, okay? I'll go through a couple of these because they're going to be familiar to you and they're not necessarily digital health, but we'll get to some of those. So the first one, knowledge processing, patent granted to Intuit for TurboTax. We've all used TurboTax. Well, what is it about TurboTax that's patentable? A system and method for identifying, prioritizing, and encapsulating errors in the accounting data. So it's just increasing the accuracy of how the data is actually received and then translated to the patent office. I mean, to the US Treasury. And you think that, okay, well, can't you do that mentally? You can. However, this is an example of a patent where you say, well, if it's just mental and we've doing it before, why would that be allowed? But when this patent was granted, that standard wasn't quite as strong as it is today. So that 7 series patent, you see 7685082, was granted. Speech, Siri, think Siri, intelligent automated assistant, patent by Apple, okay? Everyone uses all the time. That's actually an AI invention. That's patent. And again, the 10 series patent tells you that's a more relevant patent that we're really going to think about as guidance for our discussion about whether it's patent eligible. Evolutionary computation. Here's a patent from Chevron, predicting the availability of petroleum reserves. Okay. Again, a lot of stuff sounds like mathematical computation, mental abstract steps that can be taken outside. But then there's another side of that, which is, well, how much effort would it take? Can you do, is it transformative in a computer environment? Is there a machine involved specifically for this purpose? Those are the sort of things we're going to look to. Machine learning, recent patent by Walmart. Algorithm to optimize e-commerce platform by classifying product features using crowdsourcing. Another example of this would be Amazon. When you go into Amazon, you buy one thing and they say, hey, what about these 3 other things? You like to buy those too? I'm sure you do, because you buy stuff like this all the time. And we've been watching you and we've been listening to you and analyzing your data and coming up with an algorithm about you and then serving you up potential products that you might want to buy. This stuff is happening. It's ubiquitous to our lives. Planning and control. So patent by Fisher Systems, reduce the costly workflow analysis when abnormal conditions occur in processing plants. So these are just kind of a subset group, but these patents, believe it or not, these were called out by the patent office as being good examples of patents that should have been granted. Okay. And as we get into it, you're going to see other patents that are very similar to these that weren't granted, and you're wondering why. Look at the explosion of patent filings in the AI space. Okay. They have an art unit dedicated just to AI. They're tracking this. And if you look at 1990, okay, I know it's not zero, but man, it's pretty close. Okay. That's where AI started in terms of the patent office. Okay. And then we have this explosion of filings. I believe we're up to almost, sorry about that. 80 to 90,000 a year right now in terms of patent filings in the AI space. And I want to emphasize, there's these buckets, okay, because these little lines here represent essentially trail lines dedicated to the different buckets. Planning and control, knowledge and processing are clear leaders, right? That's where majority of these applications are being filed. But then you see tick up here, you see machine learning kind of going along here. And then 2015, it's starting to kind of hockey stick up here. Machine learning is on an uptick, vision, and then AI hardware. And then you got natural language processing, speech, and evolutionary computation kind of muddling along here. But there's clear areas where there's an upswing and there's clear areas where it's just staying stable. But the patent office is tracking this stuff and they're treating it differently than software. We all know that AI essentially is an advanced form of software, but they're not labeling it as software. They're labeling it and they gave it its own class. Class 706 of patents is dedicated just to artificial intelligence, purely artificial intelligent inventions. And here's the definition of that. Why is that important? It's because they're now going to take that bucket again and treat it differently than just a regular software invention. There are some that argue that are well known, will say why it's just software and it should be treated like everything else. And there are others who are saying, yes, this is leading us down a different path and we need to track it and treat it differently. And you'll see the allowance rates. And that's the allowance rate is where the examiners stamp it and say, yes, granted, actually change depending on whether it's AI versus software, whether it's subject matter eligible or not. So here's an example in the healthcare space of a claim that was allowed. Recent patent, Cincinnati Children's Hospital Medical Center, it's basically a text engine, builds an ontology by simulating various human memory approaches. Okay. Now, I'm not going to bore you by reading you every single one of these limitations here. But when you look at this claim, I think I'm almost there. Sorry, I didn't realize it was this long. Here we go. We'll go back one. So you look at this claim and your eyes roll over and you go, what do those words mean? And how do I get one of those claims? Because I have something similar to that. This is where understanding the prior art helps a lot. Okay. Two things as a patent prosecutor that I do is I'm going to look at patents like this and say, okay, if I have an invention, let's say here at Brown, I'm going to look at other patents that have been granted to say, hey, it's similar to this invention here. Oh, look, here's how they claimed it. Why? Because it matters. Those words, it's not just that's inventive, that's novel, non-obvious, We're worried about whether or not is it going to be classified as artificial invention, artificial intelligence invention, because if it is, that's going to make a difference on the art unit allowance rate. And two, it's going to matter whether it's even subject matter eligible. If I don't put the right, let's call it magical words in this claim, then that claim will be rejected based on a 101, which is not eligible for subject matter basis. So this is the way I approach it. The other way I approach it is when you're looking at, not only are you looking at similar patents, but the patent office has given us guidance too. Here's another example. Patent office has given us examples. In 2019, they started publishing this in the Manual of Patent Examination Procedure, where they literally start listing out just claims. They say, look, if you're in the AI space, in the software space, and you want to claim something, put it in this sort of Trojan horse format of claims, okay? And if you do that, you're likely to not at least get a rejection on a 101 basis. 101 is the key hurdle in AI software, okay? Again, is it eligible? Or is it just a mental abstract? So here's another patent vision in the vision category owned by the Mayo Foundation and Arizona State University. The systems and methods for automatic polyp detection using convolutional neural networks. And again, I'm not going to get into all the particulars on this particular claim, but you should be aware of the fact that all of these elements were essential to saying that it's eligible for subject matter, tying the system into its functionality, making sure that there is not just a list of mental steps that you have involved. And there's a broad category, and these are just a few of the examples of where AI is being used in healthcare and getting patented, okay? Diagnostic processes, improved and more accurate diagnosis and treatments, machine deep learning medical tools, AI-enabled assistance, automated processes and robotic surgeries, drug discovery, telehealth, neural networks, patient flow optimization. The list is it's extensive, and I'll tell you, there's a vestige here with software and people that create software, or quite honestly, people that are even into data analysts, that a lot of that stuff is just well known. They're just regurgitating things that were done before, and they're reusing line code, or they're not really creating anything innovative. And if you see the explosion of filings in this case, and you see where this is going, that's not what most people believe. Most people believe now that the patent office is going to grant them patents in these areas that may have one time been written off, like diagnostic processes. So these are the three hurdles, okay? We've already talked about novelty and non-obviousness. Again, is it taught by a single reference? Is it obvious in light of the prior art, meaning two or more references? But these other two hurdles, 101, which we talked a little bit about, was, does it meet the requirements of being subject matter eligible? And there's a myriad of cases and decisions about that. And then the other one is, can one of ordinary skill in the art make and use the invention? This is not a criticism, but there are people that are very busy that don't have a lot of time to fill out invention disclosure forms. And Melissa would kill me if I didn't say this too, which is, it helps a lot, especially to us as patent prosecutors, to have that input, output, and then what happens in between, okay? And that's sort of like, almost like a block diagram step of how that AI invention works is absolutely critical to its evaluation. Because if we don't have that, A, it's hard for us to decide whether it's even patentable, and B, at the onset, you're going to have an issue, what we call written description rejection, which is if the one of ordinary skill in the art, not you as the inventor, typically inventors, I think, aren't ordinary, they're extraordinary, okay? So in order to come up with invention, you have to do an extraordinary act and invent. Ordinary people are people that work at the patent office, okay? And they typically have bachelor's degrees. They can't pay enough to bring the PhDs. They have some, but it's dominated by bachelor's degrees, people with bachelor's degrees, and not a lot of industry experience. Those are the ordinary people. So if you just go from point A to point B without any explanation in between, we're going to get these sort of rejections. So please help us in that regard. And now I'm going to turn it over to Alex Barakis, and he's going to talk a little bit about, again, section 101 and the requirements that we need to describe to the patent office so that we don't get rejected based on a not eligible subject matter patent.
Okay, thanks, Dan. I don't speak as fast as Dan does, but I'll try to get us through as quickly as possible here. Okay, the four requirements here. We have basically only one patent will be granted for each invention on a patent application. I mean, there might be multiple aspects that are patent worthy within the same application, and those can be spun off in separate applications, such as continuations. But for each claim set, only one patent will be granted. As far as the utility, the invention has to be useful for the field it pertains to. In other words, if your invention is, let's say, a new mousetrap, well, it has to be good and useful for catching mice or killing mice, whatever the case may be. You cannot overcome a utility rejection from the patent office by arguing, for example, that a sophisticated electronic device is useful as landfill, right? I mean, it has to be useful for what it's for, okay? Now, an invention is eligible for a patent if it's a process, a machine, an article of manufacture, a composition of matter. Okay, but there's exceptions, as we'll see on the next slide as well. In addition, it has to be invented by a person. Recently, there was a case that I think Dan talks about later on where an artificial intelligence module created some output that it was argued, okay, the AI entity here is the inventor, and you know, that didn't fly. It has to be a person. I mean, that's how it has to go. So the exceptions I talked about, basically natural phenomena, like, you know, chemical X reacts with chemical Y. You're not necessarily going to be able to get a patent on that. Laws of nature, such as gravity, you're not going to be able to get a patent on gravity. Just, you know, it's part of nature, it exists. Abstract ideas, that's where the software rejections usually come in. You know, that covers mathematical formulas, organizing human activity, you know, like a spreadsheet, let's say. Let's say you have a particular process with a spreadsheet, and then you decide, hey, I'm going to write a program that's going to automate this process. That alone will not be enough to get you a patent, because if all it does is organize your activity. Also, if it's a mental process, if you're thinking about something where it's math or some type of procedure, I mean, that's not going to be patentable on its own. Also, programs that simply filter content, you know, that's not going to pass muster. If it's a fundamental economic practice like hedging risk, let's say, or advertising, that won't work either. Now, there's been a number of cases, some of which are shown here, the Alice case, the Myriad, the Mayo, and the Bilski. You know, they've all gone through the Supreme Court. The Supreme Court basically has shaped these exceptions, and they continue to evolve as we go along. They've had a significant impact, actually, and now we have a two-part test that we almost always have to apply to software. But if you could hit the next slide there. Okay, here's that two-part test. I mean, basically, this shows the overview of the overall flow chart for the patent eligibility test. It was introduced in the Mayo case, but it's also heavily relied upon in the Alice case as well. And you know, it really hits home with software, because patent examiners will almost always issue a 101 rejection because of the recent cases. So the analysis basically focuses on distinguishing between patents that claim the building blocks of human ingenuity, as the court said, which is not allowed, versus those that simply integrate the building blocks into something more, which could be a patentable invention. And obviously this is a bit subjective, and the decision maker, which oftentimes is the patent examiner, has some discretion. So, you know, starting at the top here, you look at the claims. If it's is it a process, a machine, an article of manufacture, a composition of matter? If it's not, you're not eligible. I mean, that's it. That's the end of the process. If it is, then the first part of the test is assessed. Is the claim directed to one of the exceptions, a law of nature, natural phenomenon, or an abstract idea, as well as the others? If it's not, then you are eligible. That doesn't mean you're going to get a patent, but that's going to mean the patent office is going to entertain it. They're going to assess it, examine it, and so on and so forth. Now, if it is an abstract idea or falls into one of those exceptions, that doesn't necessarily mean you're dead in the water. I mean, it's still going to be looked at the next step is, does the claim recite additional elements that amount to significantly more? The significantly more is important. Since it's an abstract idea, generally it's not eligible. So now you have to show that you're doing more with that. You're not just trying to claim that abstract idea. So, for example, a mathematical formula, that's certainly alone on its own is not going to be eligible for a patent. However, if it's incorporated into a software program that performs cryptography, that is certainly software eligible. And there's many patents out there on cryptographic algorithms and implementations.
So these are just some of the cases that Alex was alluding to earlier. And this was the first kind of warning shot that software patents were going to undergo some real choppy waters at the court level, and it started in 2010. So we've been in this sort of the courts making decisions at the Supreme Court level after being a very dormant and sort of boring area of law. In fact, that's why I chose the area of law. I thought it was kind of boring, and I thought like there wouldn't be a lot of cases. No, all of a sudden in 2010, there's just case after case after case come out. The Supreme Court took a great interest in getting involved in software. And the reason why we keep talking software is because, as the chief IP counsel for IBM said recently at an AI conference in DC, AI is software, and that's the kind of perspective that a lot of the analogies to these cases are falling on AI as well. So in this case, Bilski, it started with, well, the patent was invalidated, and they said we need to have this sort of machine or transformation test, and maybe that's a clue as to whether or not it's patentable. They talked in this case about a business method. A business method would be literally like putting something in an Excel spreadsheet and calculating. That's just a pure business method. And they were starting to outline, again, they started with this sort of machine transformation test, but then we get into Alice, which came in 2014, and now the patents were held to be invalid because the claims were drawn to an abstract idea, and implementing those claims on a conventional computer was not enough to transform that abstract idea into patent eligible subject matter. Whoa, that sounds like almost all software. Okay. And so that's when things started getting really difficult for software applicants. And it got worse. In fact, I have a quote here, kind of interesting quote from the former chief judge of the Federal Circuit who was part of these decisions, that Alice and its related decisions are excessively incoherent, inconsistent, and chaotic. So the idea is that once the Supreme Court and the Federal Circuit started getting involved in evaluating and trying to come up with some tests that everybody could agree on as to what was going to be patentable or not in the AI software field, that didn't happen. And it just led to a lot of difficulty in determining what's patentable, what's not. But good news is there are patents that have been allowed, and very recently, and now we're getting to digital health. So here's a patent 10.354.171, talk about deep learning medical systems and methods for image construction and quality evaluation. Okay. Now, if you get into this, it's talking about medical images, comparing, contrasting, creating almost like a table, and then comparing that table and then leveraging that into an output. Sounds a lot like we've been doing for years. And so we're still in this sort of like, okay, does that seem like it should still fall into these Supreme Court decisions? And I was talking to a friend of mine who's a software patent litigator today, and he said, when you're enforcing an AI or software patent, the first thing they're going to say to you in terms of the defense of that case is what's called an Alice motion. And an Alice motion is going to say it's not even eligible to be patented. And 80% of the cases that were filed in the United States last year, the Alice motion was invoked against a enforcement of a software AI invention. So these are the sort of hurdles that not only you're going to encounter at the patent office, but even after you get the patent on, again, another one that we have here is, go back here, systems and methods for processing natural language queries for healthcare data. Again, if you read the elements of this abstract here, you're going to see a lot of similarities to other things that are out there already. And so that's why, even though you have a recent patent and it applied the rules and you feel very comfortable, there's going to be still a level of uncertainty that you won't find with other let's say it, outside of life science is also another area. We didn't talk too much about that, but life science and software and AI, those are the areas that even when you get a patent, you're still wondering, how hard can I push this patent when I want to enforce it against others? Or how likely, another way to say it is, how valuable is that patent? And this is where the call to have legislative action has continued to ring. Another one here is digital platform to identify healthy conditions and therapeutic conventions using an automatic and distributed AI system. Okay. And if you look at this, I've read this claim today and I'm like, this is again another example of something that I don't really actually know if it should have been patentable in the first place, not from a 101 as eligible standpoint, but some of this stuff seems very common that's being done today. And that's more of a novelty rejection. But then there's good news. So we're not here to just tell you that, all right, this is going to be difficult, because then all of a sudden the Federal Circuit in 2016, so we started in 2010, 2014, Alice comes out, which everyone said was the death knell of software. And I think Alex was thinking, maybe I should do a career change. And then 2016 comes and then out comes NFISH, and it basically says, hey, you have a self-referential table, which is a specific type of data structure designed to improve the way a computer stores and retrieves data in memory using a 4-step algorithm. That is specific enough to be an improvement, and therefore that's patent eligible. I don't know why this case actually is any different from some of the other cases. But then the same year, the Federal Circuit had 2 inconsistent decisions. The Electric Power Group case comes out and they say the collection, this is dicta now, the collection, analysis, and display of data may be ruled out, meaning that may not be enough. And again, what are we doing in AI? Collecting data, analyzing, creating a model, and having output display. So again, these decisions aren't giving people in the industry comfort. But meanwhile, as you saw that graph earlier, during this time, people are still accelerating their filings. But here's the choppy waters that we face. Okay. After these decisions, and now you have this graph, let me just explain it. On the x-axis, you have time period of action from 2012 to 2022. And on the y, you have a percentage of office actions with 101 rejections as subject matter eligible. And then the first dotted vertical line you have there is Alice. Okay. And remember, that's the one that said, hey, it's all over, software patents not going to be eligible. Then in Electric Power, which was the one that said, hey, they're really not eligible. Okay. And you can see the effect that had. The first one didn't quite have that same effect, but on the AI class 706, look what 2016, 2017 time period. This is bad. The allowance rate, the disallowance rate based on 101 rejections went up from somewhere in the 20 to 40% up to almost 90% within 2 years. Okay. So the choppiness, then you see it almost plateau at 100%. And then the patent office comes where they saw new guidelines. That means the patent office came up with its own set of guidelines. Now, this isn't the courts. The patent office steps in and says, this is absurd. And they come up with their guidelines, which I talked about are basically examples of what they'll accept. And now the 101 rejections went from almost 100% down to the more normal phase of about 20 to 40%. And so you have this government agency and the courts, kind of almost the executive branch and the courts vacillating back and forth, and we're caught up in the middle. The other thing to note about this graph is where bioinformatics holds true, which is really hasn't stayed, it's pretty much not subject matter eligible for quite a few of those cases. 80% of the time, you're going to get rejected on a 101 basis, and business methods as well. Even though recently there's been maybe a tendency to drop that, but it's still the very difficult areas to get patents through. And this is why we do what we call art unit shopping. Okay. Because if you're classified in art unit 1631 and they have a disallowance rate of 80%, you're dead on arrival. But if we can classify that, let's say in the straight AI case, we have a 20 to 40% chance of getting allowed. I mean, a disallowance. So it's actually very good. So it lends itself to a lot of this form shopping. We'll talk about how to do that. Alex?
Okay, section 112 has a written description requirement. I mean, here the slide says, it's for AI inventions, but actually it's for all inventions. And basically this says that this basically shows why it's so important that we get complete disclosures, the more the merrier. Flow charts, very detailed specifications. I mean, the more we have, the better written description we can put together in the patent application. Basically, this section 112 requires that the specification contain a written description of the invention, how to make it, what is it, how to make it. It has to be clear and concise, exact terms to enable someone of ordinary skill in the art, right? Now that can vary how that's defined, and there's a lot of case law to that effect, but that person should be able to make and use the invention just by reading that patent application without undue experimentation. In other words, you can't hide the ball. You can't hide the secret sauce, in other words. And a lot of times inventors do that. They'll give a disclosure, but they'll try to hide the inventive nugget. That only harms them. And if it ever came out in the future, in a litigation or whatnot, potentially the patent could be invalidated for that if it was done intentionally and in bad faith. So as far as declaring the best mode, let's say like in software, if you know your software invention runs best with a particular processor or on a particular platform, that needs to be disclosed. Don't hide that. You need to disclose it, and it needs to be included in the patent application. If it's a chemical invention, and let's say you happen to know that 75 degrees Fahrenheit is the ideal temperature for some type of chemical reaction, then you need to disclose that. If not specifically a 75 degrees, you can do it with a range. If you say, you know, from 60 to 80 degrees Fahrenheit will work, if indeed that is true. So that's the important takeaway on the written description there. On the next slide here. So to avoid rejections here, you know, as I was saying, the more detail, the better. Don't just assume, try not to use acronyms. Don't assume that your audience is going to know exactly what you're talking about. You know, someone of ordinary skill in the art, depending on what it is, it might be a PhD researcher that's on the cutting edge of technology, right? That's not everybody. That's not every engineer or every scientist, right? So when these patent applications are written, it's best to write them not for the PhD researcher or the valedictorian, but write it for the engineer that barely made it through. In other words, I give enough explanation so someone of ordinary skill like that can understand it. You never want to find yourself in a courtroom in a patent infringement case trying to argue that your patent is enabled and there was adequate disclosure. Like, that should never be an issue. That should, you know, right from the outset, that should all be covered. Full disclosure, no hiding the ball. And I don't want to use the phrase dumb it down, because that's not actually what I mean, but the disclosure should be such that people can understand it. I mean, let's say it's written by a PhD researcher in AI. Okay. It should be written in a way where someone pursuing a bachelor's degree in computer science, or someone who has just a bachelor's degree in computer science, that person should be able to understand it just by reading the patent application.
So as in the last prong we talked about is whether or not an AI, can artificial intelligence be named as an inventor? The answer is no. There's been
Break it up.
Can you hear me now? So the answer is no. You can't have an AI in the United States. AI cannot be named as an inventor on a patent. That is the law of the land today. It may change in the future. There are people on both sides of that issue here in the United States. Some people argue that it's no different than there was a decision, believe it or not, a long time ago about a camera and an image, and who owned the image. Was it the person that built the camera, or was it the person that took the photo? And the answer was it was the person that took the photo, so it's the user. There's also a thing called, you know, well, the bottom line is, in the United States, it's clear that AI right now is not going to be named as an inventor, but South Africa, if you ever want to file in South Africa, they do list AI as an inventor, and that will only make things more complicated because you're going to have different inventors in different countries. So I want to kind of leave you with some tips on specifically prosecuting AI inventions in the digital health space. And then we're going to talk a little bit about patents, trademarks, copyrights, and trade secrets a little bit. But the bottom line is, when you're looking to avoid these hurdles, okay, that we talked about, 101, subject matter eligibility, 112, written description requirement. Those are your two biggest hurdles. Of course, novelty and non-obviousness, that no one else has done it before, but you want to focus on these things. If you're focusing on system components and their technical functionality, that helps a lot in terms of avoiding that it's just an abstract idea. If you don't have that sort of computer architecture tied to the technical functionality, they tend to throw that in the business method units. And that's basically what we call the death chamber for patents. So we're going to have to put it in that context. And I heard this strategy recently. I thought it was interesting. You almost in the background section of the patent explain why it can't be done in a person's mind. Again, the hurdle is going to be abstractly, that this could be pursued abstractly, a mental concept. Why don't you anticipate that and be able to explain why, wait, the other people have tried and failed this. They can't do it mentally. They can't do it manually. And here's why it can only be done in a computer setting using AI or software. Diversify your claims into multiple categories of claims. Don't just limit it to a process. You can also use system claims, network claims. There's a wide variety of claims, and some of those claims can be more fruitful than others. Art unit shopping. I use patent bots myself here at the firm, which is an AI tool that we use where you can actually upload your patent specification and it will determine what art unit you're headed to, okay, with about 80% accuracy, which I think is pretty amazing. And patent bots opens up the door, and the patent office started doing this year. They're now starting to use AI to search for prior art, okay? And there are more tools coming out around using AI, and they're even talking about using AI as a person of ordinary skill in the art, which will be a fascinating endeavor as well. No black box claiming. Black box being, input, output, and something magical happens in between. That is definitely going to be a problem from a written description requirement, and probably even a 101 requirement for AI software. And think enforcement of the claim. When you're thinking about what's important about your invention, you got to look downstream and say, who's likely to infringe on this AI invention? Who's going to practice this? And then reverse engineer what a potential claim might look like. Alex, do you have any comments on this?
Well, it's pretty thorough, but I'd like to add that, again, it's best inventors should provide the very detailed information disclosures. Flowcharts, specifications, the more the merrier, the better the patent application will be. Don't hide the secret sauce. I mean, that's key right there as well. That could lead to a lot of trouble. Also, the more detail that's provided for the application, the more retreat positions you have. And by that, I mean, let's say we file a patent application. Okay. The examiner starts examining it, and all of a sudden he finds a patent application, which may be obscure or maybe some thesis on some shelf in some other country that is dead on. I mean, let's say they have you. I mean, you're going to be rejected outright. If you've provided enough detail covering all other embodiments, other aspects of the invention, then it's possible to find a retreat position. And by that, I mean, okay, you're not going to get the claims you originally wanted, but now you have enough detail in the specification where we can modify those claims to get you something, right? We can retreat to a lesser stance, in other words, or a more narrower stance, more accurate.
Okay. Switching gears here because I don't want it to be, hey, patents, AI only. Think broader than that because they're trade secrets. Now, again, we have a trade-off. When you put something in a patent application, it will publish, the whole world will see it. And that at a university setting, that's what we like to do. So trade secrets are difficult to really think about here in the university setting. And I'll tell you, even more so the AI inventions. A lot of the AI inventions that are happening are basically happening because we have increased computing speed, advanced technologies that allow us to discover things we couldn't do before. That means that the speed of innovation is going faster than it's ever has. So the idea that you have a trade secret for an indefinite period of time, which is what the trade secret law affords, is less likely to happen today than it ever has before because of AI. So the other way to look at it is if you're going to use trade secrets, you have to be really sure that as the advancement of AI occurs, that you're not going to be able to obviate that or reverse engineer that trade secret and obviate its protection. And then the other part of it is what quality of patent you're going to get. If it's truly just something that's not really lending itself to a patent, is there any value in filing it? And maybe you are left with the trade secret. And that's where contract law comes. Even in a university setting, we can think about licensing and protecting trade secrets, and that's where trade law, contract law comes to play. The other doctrine we should think about is copyright. Okay, and copyright affords itself protection. And again, we talked about the bright line categories, but it also can protect data. It can protect with a minimal degree of creativity, and there's a lot of case law on what that means. But the bar is so low that I don't believe there are very few cases that have ever said no. There's not a minimal degree of creativity, other than a famous case about a phone book. Software source code, clearly eligible for copyright protection. Graphical user interface. And the challenges with copyright, though, first of all, same issue with copyright as with patents. Authors, as of right now, Copyright Office said authors cannot be AI. So you have to be a human being again to be an author. And real recent case here, Authors Guild versus Google, where if you have an AI software and you're training it up and you're using, let's say, copyright images from somewhere else, is that an infringement? And in this case, actually, Google won. And they said, hey, we're using these digitized images of these books to train up the search engine. Are we committing acts of infringement? And the court said no. Supreme Court said no. So there's other issues involved with training up your AI model, and you have to be aware of that as well. And the last doctrine, trademarks, talked about it briefly. Do you keep the AI behind the wall? And again, there was a recent speech by Amazon Chief IP Counsel saying, hey, we have a lot of AI, but we like to keep behind the wall. We don't want to go out there and talk about it. And whereas IBM's out there saying, yes, Watson, please. In conclusion, I think the three bright areas I want you to think about is AI is patentable. Okay. That means AI is protectable at a university context. Okay. So when you see all these hurdles, this isn't to say, oh my goodness, forget it. We're never sending an invention disclosure to Melissa Simon, because that would be bad. Okay. The purpose of it is to make you aware of how important your contribution is to that inventive process, and why, as Alex said, having those detailed disclosures helps a lot in evaluating and understanding the possible strategies that you can use to protect your intellectual property. The second thing is that AI is not just patents, it's broader, it's trademarks, it's copyrights, it's trade secrets, it's contract law, okay? Because a lot of contracts now, they're talking about using contracts in congruence with AI to basically shore up some of these holes, okay? What happens when you have an AI as an inventor? Well, we already have a doctrine that you can assign your inventions. So maybe when you create the AI, you already have a doctrine that says they will be automatically assigned to an inventor or to a company. And document your process, okay? If beyond just the disclosure, there's a lot of documentation that's required for AI in particular. And that is going to slow you down a little bit, but it's really going to help us a lot in terms of identifying nuggets of gold that are protectable and utilizing some of these tools to get there. With Alex, do you have any final comments?
No, just on the copyright slide, I mean, you don't necessarily need to show it. It was 39, I believe. I mean, I just wanted to add, copyright's basically, it's a good secondary protection for software, because it only protects against copying. If somebody doesn't copy you and they make the identical software, I mean, you're not going to stop them with a copyright, right? They didn't steal from you. They didn't copy. That's why patent protection would be much better if it's available for your invention. That's all.
Okay. And that concludes our slide deck presentation. Melissa and Allison, are there any questions?
Thank you, Dan and Alex. There are a couple, but if others pop up, feel free to raise your hand in the in Zoom, and I can call on you. One of the questions that came up sort of earlier on was talking about how you put in sort of ranges in your patent to try to sort of broaden what you cover. And so if you have any examples or any guidance on how you can include ranges in claims.
I assume that's in relation to the example I gave with the temperature.
I would assume so, yes.
Well, in that type of range, each of those temperatures, let's say it was 60 degrees to 80 degrees, each, the invention has to work. Let's say it's a particular reaction. It has to work with each of those, any temperature within that range, right? You can't extend it so that, let's say you said 50 degrees to 70 degrees, and it doesn't work at 50 degrees. You can't do that. But if it works at, let's say, 60 to 70 degrees, and you specify that, but you happen to know the ideal temperature is at 65. Technically, you've disclosed it, right? Because you've given the temperature range. Any temperature within that range will work. So I guess you have to be truthful, right? Just give a truthful response there, and you should not run into any trouble.
Good. Another question, which I feel like I should probably answer, but I'll pass it over to you guys to give your thoughts, is how early in an invention process should you facilitate talks with an IP lawyer or the tech transfer office? Just before publication, or is it appropriate to begin it when the project is just in its nascent stage?
Melissa, that's your question. I'll answer if you want me to, but I mean, it's up to you.
You can answer it.
All right. I mean, as early as possible. I mean, there's no, clearly reaching out to Melissa isn't going to incur additional cost to Brown University. So reaching out to your assigned person here at Brown is going to help a lot. Because number one, you might have enough. A lot of times people are always waiting for the validating data that says, okay, this thing works perfectly. Let's get the manuscript fired up and get it out. You don't need to wait for that moment in patent law. Okay. Patent law is a different game from research. What we're doing is, through provisional patents usually, is securing our earliest filing date so that we can cut off the prior art that's going to be used against us and those hurdles that we talked about, like novelty and non-obviousness. And even though it's not fully fleshed out, as long as one of ordinary skill in the art can make and use it, not that it works well, okay, that's not a requirement at the patent office. Certainly for research, that's important. But for a patent office, it's not even material suggestion. What we need to do is say we have control over the invention. We have enough detail to support what we posit that actually says that it does. But at the end of the day, it doesn't actually have to work well for it to be eligible. And I think if you start that engagement and talk through Melissa, or if she connects you with us, that there would be a very fruitful discussion for you to understand, where am I going to take my efforts further? Maybe I was going to do all these validating studies. Maybe I don't need to do those. Maybe this is a time to actually reflect and see if there's anything patentable here, so that if I am at a crossroads and I can maybe pivot towards an area where there's more fruitful patentability, I might find that in the same amount of effort. So I would say as early as possible.
Sounds good. I know we're at 4 o'clock. Last question. After submitting a provisional, can we relax on disclosing some of the information publicly?
Well, that's a tough call. Alex, you have any thoughts initially? I have some thoughts too.
Well, I mean, oftentimes people want to file a provisional because of the speed, right? They want to hurry up and get a filing date so they can go out and pursue venture funding or talk to business partners or whatever. And if that is indeed the case, then I would say yes. You can relax on disclosing the information publicly, provided you fully disclose the invention, it was well written, there's nothing missing, you've captured the filing date. If you're not under the gun, if there is no pressure to go out and get funding or whatever the case may be, then you could continue to wait and don't make the disclosure. Like, don't make unnecessary disclosures if you don't have to.
Yeah, I think you said it perfectly. I would add to it that I almost look at it like 3 layers of protection when you're disclosing, when you're talking about your invention. 1 is obviously have a patent on file. 2 is actually having a non-disclosure agreement, not always possible. And 3 is being careful about what you actually reveal in those conversations, even when you have the other 2 things in place, because ultimately other people aren't always rational and don't always act in accordance with universal principles of human justice and fairness. So, and that's not a political commentary of the day. That's just that happens in all areas of law.
All right, well, I think that is all the questions that we have. Thank you so much, Dan and Alex, for your presentation.
Thank you.
Oh, sorry, were you gonna say something?
No, I just said thank you.
Oh, well, thank you. So our next digital health commercialization seminar will be on Wednesday of this week, March 2nd, at 1 p.m. with Dr. Sharon Patel from Strategy Health, who's going to talk about U.S. regulatory strategy. And you can register using the link that I will put into the chat. And I'll turn it over to you, Allison, to close us out.
Thanks so much, Melissa. And thank you again to our speakers and to all of the folks who attended today. We have recorded this session and we'll be sending out to folks via email who registered, and we'll also be posting it on our website. We have also chatted links to a survey in the chat, so please fill that out, give us some feedback on how the seminars are going. But we are excited to continue the seminar this week on Wednesday, and we hope to see you all then. Thank you so much, everyone.